Very happy to be with you here today and excited to teach you a little bit about some of the things that you'll be getting into. The first year of law school is very intense. It's one of the most intense academic experiences, I think, in the world, but it's also wonderfully challenging. And so today's session is to help you get your feet a little bit wet and learn some things before you get here and kind of the floodgates open to hopefully get you on your way. So I've actually taken some of this lecture material from the lecture that I do on my first day of class in legal research and writing. So if you're in my section, you will hear some of this then. Maybe some of you already know some of this. Maybe you know a little bit of it. Maybe you know a lot. But always good to review and just continue to learn and really get it cemented in your minds, because the law, above all else, we're taking from undergraduate, where we kind of learned by reading a couple times and maybe taking an exam on it or whatever. Here in law school, we really seek a level of mastery that exceeds far beyond reading something a couple of times, but rather understanding it inside and out and understanding the implications and the pros and cons, and that's what it means to think like a lawyer. And so some of this feels like review. That's good news. If it's all new, that's just fine. I'll share one other quick story. I literally came to law school with no lawyers in my family. Nobody in my family had ever gone to graduate school. I just knew the people across the street here. I went to undergrad at BYU. They just looked really smart and really old. But my mom took me to see Legally Blonde. It had just come out, and I was finishing up my degree, and I didn't know what I was going to do with my life. And we walked out of the movie, and she said, "Oh my gosh, I think you should go to law school." And I was like, "Oh my gosh, I totally should." So I did. But I remember that first week sitting here just scared to death as people were spouting off all kinds of knowledge about who is currently sitting on the Supreme Court and certain kinds of jurisprudence. And I was like, the Supreme Court, I've heard of that. I think I could maybe not name one person. So if you're in that boat, that's totally fine too. Law school is an immersive experience, and you'll learn a lot, and it's good fun. So let's go ahead and get started. We're going to treat this like a regular law school class. That's why I have you have name cards, because I get to call on you. Good news is that there's no grades from today, so no pressure at all. So we're going to start with some preliminary concepts that you have to know. And I'm going to be pretty simplistic, maybe in some cases a little bit overly simplistic, but you have to know these preliminary concepts in order to even understand why we read cases. So first concept, where does law come from in the United States? 3 places. Can anyone tell me? Where does it come from? 3 sources. I know we have a 2L here. I'm sure he knows. Yes?
There are statutes that come from state and federal legislatures.
Okay, so legislatures can create law? Yes?
Precedents set by judges.
Okay, that's also part of kind of how courts can create law. So we've got legislatures, then we've got courts. We've one other place law can come from. Yes?
United States Constitution.
Okay, yes, I guess that's kind of, I guess that could be a 4th. I'm trying to think how that would fit in the structure of 3, but yes, we have the Constitution kind of underlying everything. Yes?
You mean just like common law?
Common law is kind of a part of the courts. So basically, you're all kind of getting there. We have 3 branches of government, right? And they can all create law. And this is something that a lot of people don't understand. When they think of law, they think of something the Utah State Legislature does, or your congressman does back east when they go to DC. But we actually have law from 3 different places. First, we can actually get law, if my slides will move. My slides are not moving. Oh, I'm viewing Kathleen's screen. Thank you. Law from the executive branch. So our presidents can actually create law through things like executive orders. And next, we have law from the legislative branch. This is what everybody thinks of when they think of law, is statutes, what our Congress and our Senate are working to create. And third, we have law from the judicial branch, which several of you actually mentioned. So you might ask yourself, well, how does a court create law? That doesn't make any sense. They have 2 people who come before them, and they have to decide a case, and they decide the case, and the people go on their way. So how does that work? Well, first you have to understand a few basic principles. So if we can go to the next slide. So first of all, we have 2 court systems in the United States. We have both federal courts and state courts, and they are separate systems, okay? So people think, well, if you want to start a case, if you want to sue someone, you just walk down to the courthouse and you file your paperwork and you've started the case. Well, there's actually a question before that, which is who has the right to hear that case? And this is what's called the concept of jurisdiction. Okay? So jurisdiction is the idea that each court, federal or state, has power over certain kinds of matters, and they don't get to pick. So it's not like the federal court can say, oh, we want to hear that case, that seems really fun, or the state court can say, oh, that one's really interesting, we want to make sure we decide about that case. Each court has assigned to them certain things that they can hear, and that's what's known as jurisdiction, the authority to hear something. And depending on what your case is about, you're either going to be in the state system or the federal system. And again, you don't get to pick. The laws create, this is a federal matter, this is a state matter, okay? Next slide is that within those systems, they have different levels. So people will say things like, take your case straight to the Supreme Court. Well, that doesn't work with very few exceptions, which actually are outlined in the Constitution. You can go look at all of them. But for the most part, you do not start at the Supreme Court. It's very, very rare. You start at the very lowest level. So within the state structure, there's a structure where you start at a trial court, if we can get the slides going here. So you start at the trial court level, and then you can appeal to the State Court of Appeals, and then the State Supreme Court. Now that is the end of your state matter, okay? Unless you have two things that happen. Does anyone know what one of those two things are? To get to the U.S. Supreme Court. I won't put our ASP mentors on the spot, but there's two requirements. First, you have to have some kind of federal issue involved. So if the question is about the Utah State Constitution, and you go all the way to the Utah Supreme Court, and it's just a question about the Utah Constitution, that is the end. The U.S. Supreme Court does not have the power to come in and yank that out and say, we're going to decide about this. But if you can find a way, and this is where it gets a little bit more complicated, but if there is some kind of federal issue involved, then you can look to the U.S. Supreme Court, and then you have to apply for what's called certiorari. Okay? You have to ask the court to hear your case, and they can either grant or deny cert. So both of those conditions have to be satisfied. Otherwise, the Utah Supreme Court is the highest level in the state court system. There's, on the other hand, the federal system. And within that, you start at the district court, and then you can go to the Circuit Court of Appeals. Does anyone know what circuit court we're in Utah? You can look at the map. You all learned something new today. 10th Circuit. So here we're in the 10th Circuit. So you start at the district court, then you can go to the Circuit Court of Appeals, then you can go to the Supreme Court. And here there's only one requirement. Why? Because we're already in the federal courts. We're already dealing with federal issues, so we don't have to ask, is there some kind of federal issue? But you still have to apply for cert and be granted cert by the court, because the court can't hear, of course, every single case that needs or that wants to be heard. They have to grant cert, okay? So that's the two levels of courts, and you start at the bottom and you work your way up, okay? Now, common law. Somebody mentioned common law. Common law is the idea that every single time a case is heard, the decision that comes from it is actually a piece of law. Okay? So we start with, let's say, a very general statute about trespass. Like, trespass is the intentional unauthorized entry onto the property of another. And the state legislatures put that law in place in Utah, and they say, this is great, we're going to make sure nobody trespasses in Utah. This is the law. Well, then somebody is taking medications. They have a psychiatrist, and the psychiatrist prescribes them a certain medication, and it actually puts them in an altered state of reality, and they accidentally trespass late at night onto somebody's lawn, and the person sues for trespass, and all of a sudden we say, intentional. What does that word mean? Does intentional mean like they had to be lucid? What if you were on medication? What if you were sleepwalking and unconscious? What does intentional mean? And it goes before the courts, and the courts have to figure out and fill in the law. So if you think of statutes starting here, the courts fill in all the law underneath with what these things mean and how they're interpreted. And that's all what's called common law, okay? There's also what's called civil law jurisdictions, which are different countries have civil law, where the statutes, the law tries to actually outline, the legislatures try to outline every single possible exception and nuance and everything like that. Here in the US, we have the statutes, and then we fill it in as we go to the courts and find out what the law means, okay? So that's common law. Well, you might say, okay, but how do I make an argument as a lawyer if the law's already been decided? If I go look up trespass, and I had a client who was on medication, and I see the exact same case, and it was decided, how do I ever make an argument? Well, there's four major ways that lawyers make arguments. The first is there's what's called mandatory law and persuasive law, okay? Now, if you see this waterfall, law works with a trickle-down effect. So that means every court above you in your line, in your waterfall, creates mandatory law. So if you're a Utah State trial court, you are bound by the Utah Court of Appeals and the Utah Supreme Court above you. You are not bound by the Oregon Supreme Court, even if they've decided the exact same case, because they're not in your line above you, okay? So think of it like this waterfall with the trickle-down effect. So the very first way you can make arguments is by saying, Your Honor, absolutely there was a case, but it was a Colorado case. That's a persuasive case only. It's not mandatory. We're not bound by it. We're not underneath that waterfall. We're in a totally separate jurisdiction, and we would like you to decide for Utah law differently for XYZ, and you make your arguments, okay? The second way is what's called analogizing versus distinguishing. So let's say you did have that medication case, but your client was sleepwalking. They weren't on medication, they were sleepwalking. So you say, Your Honor, I understand that Utah has already decided this case for those who choose to take a medication. However, my client is different, and here is how, and here's what makes these things so different. And of course, the other side will get up and say, no, this case is exactly the same. It needs to be decided the same way. So that's the second way you can make arguments using common law. The third way is what's called dicta versus holding. So judges, each branch of our government has their hands tied to some extent, right? Because they only have certain powers. So it's not like they can go out and do whatever they want. It's not like courts can come out today and say, well, we've decided we really don't like the new Utah law on this, so we're going to create a new law. Courts are most restricted by the fact that they can only decide the cases in front of them, with the facts in front of them. So sometimes judges will do things like say, in this case, we're going to hold for the plaintiff, but if we had had facts A, B, and C here, we would have held for the defendant, okay? The problem is that if we had had these facts, statement is all what's called dicta. It's just what we would have liked to do, but it's not law because they are bound by just the facts in front of them, okay? So that's how courts are most bound in terms of their power. Lastly, there's what's called enforcing versus declining. If you paid any attention to U.S. Supreme Court cases, you've seen cases where the court has flipped on its head. Civil rights cases, for example, where the court has said, yes, we used to do that, but it was wrong, and now we're going to do this. Enforcing versus declining. Now, I wouldn't recommend you usually make these arguments at the trial court level, like, Your Honor, we think you should totally change the law for my client, but that's how these cases start. So I wouldn't recommend that you make that your practice every single time. Hopefully you can rely on these other ones, but occasionally it happens and you make those arguments. Okay, now on to cases. That's what we're here to talk about today. So the first question, what am I reading when I read a case? Like, where does it come from? Who writes it? Does anyone know? When you read a case, you've seen those case books, right? They're big, they're thick, they're filled with cases. What is a case? Who writes it? Where does it come from? What does it have in it? You read a case for today, hopefully. Does anyone know? Any ideas? Yes?
It comes from the judge's opinion or ruling of the case.
Okay, good. So the judges, when they hear a case, write an opinion, and the opinion isn't just you win and you lose, right? Because we're creating law here. So we need to memorialize what was done. So when you read a case, you're reading opinions that are not just you win and you lose, but that actually seek to set out the facts of the case and say, here's what happened. And then set out, here's kind of the new legal issue, the new little twist we're looking at. And then that say, well, here's what we've decided. And when we apply that new rule to this person, here's what's going to happen to him. And here's all the reasons why we did it. Okay, so that's what a case is. It's an opinion memorializing what happened, and then it allows attorneys to go research and find out what happened and how it's going to work for their client now who has a slight twist on that, and how they're going to argue it. Or what if it's a case that's already been completely decided? Do you think those cases show up 100 times? Why don't those show up in the case books, the same case 100 times? Just from a practical standpoint. What do you think lawyers do when they find out they've lost, or they're not likely to win, or... What would you do? They settle the case, right? They do the research and they're like, oh, it's not looking good. We better settle the case. Or they tell their client, you don't have a case, right? They say, I've looked at the law and you've lost. We're not going to sue. Or I've looked at the law and you're for sure going to lose the lawsuit. So let's go ahead and make the best settlement offer we can. Okay, so what is a case brief? And that's the big thing we're going to be practicing and talking about today is what a case brief is. So a case brief, we can flip through these slides, please. Let's keep going. So let's go to the next one. So the first question is, what is a case brief and why do I have to do them? Well, I have to do them my whole life. Absolutely not, but they're an incredible, useful device that is developed over the years of legal education that is a way to teach you how to read cases like a lawyer, okay? So first let's talk about the why. Why would you even have to do a case brief? And let me first explain, I'll go back to what a case brief is. A case brief is basically a Cliff Notes version of a case. Okay, so it's you taking a case and saying, okay, I'm going to go through this case and figure out what the facts are and what the issue is and what the rule is, and we're going to go through all this in depth, and you're actually going to write your first case brief. But it's just a way to take a case and break it up into the most essential parts, okay? So you might say, well, why would I have to do that? I read the case 2 or 3 times. I came to class prepared. Well, the first reason is because of the length of cases, okay? Some cases are 2 or 3 pages. Other cases are several hundred pages, okay? And it's really easy to get lost when you're reading a 50 or 100-page case. And what's happening? Wait, what was the issue? What were they even trying to decide? The next reason that we do case briefs is because of the complexity of cases. So how many of you speak or have studied a foreign language? Okay, most of you. If not, you'll just have to imagine here with me. So when you first learn a foreign language, typically you do a word-for-word translation, right? Like, I speak French very badly. So, je, I, tu, you, right? And as you read through something, you go word for word, and you translate it in your head. At some point, for those who speak languages very well in here, do you have to look at every word and translate? No, it's just second nature, right? You hear it and you know what it means because it's second nature because you've learned to speak that language. The law is the exact same way. I've been practicing law. I've been out of law school for over a decade. Do I ever do a case brief now? No. Because I can read a case and very quickly say, oh, that was the issue, that was the rule, that was procedural history. I don't need to break it up and translate word for word. But you all are brand new to this. So yes, absolutely, you do case briefs to help you break down the complexity of cases. The other thing to note with the complexity of cases is you'd like to think that all judges write really nicely, right? Like you will all write after you get done at BYU Law. But the truth is that's not the case. So you'll get judges who write cases that they say, well, the reason we're here today is because of this, and we're going to hold this, and let me tell you some of the facts and the real issue, but some more of the facts, and it's confusing because our reasoning led us to think. It's a mess, right? So we'd like to think that all cases and opinions are just very simply laid out. Here are the facts. Here's the issue. Sometimes they don't even say this is the issue. They'll just start spouting off legalese. So not all judges are created equal, and that means, again, with the complexity issue, not only are you learning a foreign language, but they're not always the best foreign language writers, right? Sometimes it's kind of a mess. So you use this case brief to break it up. Final note, and I didn't put this in here, but it's just a practical matter. Your first year of law school, you'll be assigned your fall and winter cases, right? And so you might have torts and property and civil procedure all one semester. And for each of these classes, you're going to be assigned several cases for each day. Well, can you imagine how confusing it gets if you're trying to memorize which one Johnson v. Smith was about when you've read 20 cases for tomorrow, right? It's just not workable. And so as a practical standpoint as well, even if you've read the case really well, the case brief helps you remember all the stuff you read and say, oh yes, I remember Johnson v. Smith, okay? The other why in terms of, actually we'll get to that in a minute. For how long do you brief cases? Until you become fluent. So I think most students probably brief most cases their first year. By your second year, you're usually doing a lot more notes in the margin kind of a thing. And by your third year, you're just reading them through and you're getting it like that for the most part, okay? But your first year, this is a critical step. And if you read any, there's just no shortcuts to good legal learning. So if you read any tips that are like, you never need to brief a case or don't even worry about reading for class, that is horrible advice. I'm a marathon runner. That's my one and only hobby, and I picked it up in law school. And there's no cheating in marathon, right? You get to mile 20 and you know who trained or didn't. There's no cheating it. I have never met an athlete who ran a marathon without absolutely no running in their whole life. Why? Because you cannot cheat that distance. You can't. Law school is the same way, and if you learn nothing else from today than that you can't cheat your experience, you have to put in the time and the effort and the sweat and the blood and the tears, then that is a very worthwhile hour spent because you need to brief cases so that you learn how to think like a lawyer. It'll help you your whole life. Don't take the shortcuts. Brief the cases. Okay, so how do I do a case brief? So you say, okay, Professor Bramble, I will do case briefs. I get it. How do I do them? Okay, first thing you do is you just read the case once through. You might get some of it. If it's torts or property, you're going to feel pretty good. If it's constitutional law or civil procedure, you're going to feel like, I don't really know what I just read for 20 pages. I think it might have been in Chinese. So first, you just read the case. Just give yourself one read, okay? Second, you're going to read again, and this time you're going to look for the specific parts that need to be pulled out and go into your case briefs. And one of the simplest methods is just on the left-hand or right-hand margin of your casebook, and if you want to sell it again in pristine condition, use a pencil. You just write an F for facts and circle it, or an H for holding and circle it. You can just mark up your case that way. Third, after you've read it through again and you've got all those things marked, you go ahead and you type up or handwrite your case brief, okay? So your case brief you're actually going to create. It's not just going to be little notes in your margins. You're actually going to create a separate document. I'm going to show you exactly what that looks like. So what a case brief looks like, if we can flip quickly through this slide. So as you'll see, it's pretty simple. And this case brief, now case briefing is something that's developed in legal education over the decades. So are you going to find there's no like perfect or right or wrong way to do it. So you might look at a commercial method that says you really need to have this in your case brief, and another method that says never leave out this. This is just a very simple method that incorporates pretty much all the major elements, but if you want to vary it, if you want to put something first or last or whatever, feel free. This is what a very generic, simple case brief looks like. And I'll tell you right now, this case brief could work for a case that's 2 pages or that's 200 pages. And case briefs should not be long. I always tell my students they really shouldn't be more than a half to 3/4 of a page. Otherwise, you didn't understand the case very well. This is the Cliff's Notes version. You should be able to break it down into these very simple parts, even if it's 200 pages, okay? Otherwise, you didn't understand the case well enough, you need to go back, okay? So, what is the purpose of a case brief? We talked about why you do them, but here's some of the purposes. Again, to learn to read like a lawyer and to become fluent in the common law. Second, and this is very important, we'll talk about this more in a minute, is to learn the black letter law, and you'll hear that phrase a lot in law school. What it means is like the hardcore law, like this is the formula, this is the end of the day law, this is exactly what trespass is, or what assault is defined as. So black letter law means when we get to that meat of the law. And third, again, from a practical standpoint, to be prepared to participate when called on, meaning the Socratic Method. Raise of hands, how many people have heard of the Socratic Method? Okay, raise of hands, be honest. How many people are scared of the Socratic Method? You should be. No, I'm kidding. So the Socratic Method is the idea that as lawyers, we should be able to think on our feet, we should be able to respond, and most important, we should be able to engage in discussion. We should be thinking. And my most common question in my writing classes and to my own children is, what do you think? And a lot of times there's like a, what? I want to see where their heads are. What are you thinking as you think that through? So law school is not about spoon feeding you. Like, oh, let me tell you all the answers. It's what do you think the answer is? Well, I think maybe it's this, or maybe it's this, or and then we direct and guide and say, yes, you're right, it is that. And why did you think that? Well, because of this. Yes, exactly. Because again, law school is this other level of mastery. It's not about memorizing, it's about mastering. And being a good lawyer means thinking something through from start to finish and understanding the whys, not just thinking about, well, I can spout out that assault is intentional harmful contact, but in understanding what intentional means, and if it's a subjective standard, if it's objective, and why this was even created in the first place, okay? So the Socratic Method really is not meant to torture you. It's meant to help you think on your feet and think about the whys and really think about your answers rather than just having memorized words come out. Because I promise when you're in court, the judge is not going to give you the answer, right? When he says, well, Your Honor, or counsel, I'm really concerned about this, you're not going to be able to say, well, tell me what I should say to answer your concern, right? You have to think, well, Your Honor, that is a valid concern, but on the other hand, we also have this, this, and this going on. And so that's what it means to use the Socratic Method, is to engage in a dialogue and a discussion, and for you to be an active part of the learning, not just sitting back waiting to get the answers, okay? That being said, was I terrified the first time that Tom Lee, who's now sitting on the Utah Supreme Court, called on me in civil procedure? Yes, I was terrified, mostly because I read the case 5 times and I didn't know what it meant, right? He called on me and he said, can you please tell us about this case? And I said, yes, I can. And I read word for word from my case brief, and I didn't know what one of the words meant, but I had put it in my case brief. And he said, oh, okay, yeah, we'll work with that. And then he helped me along. So if nothing else, case briefing helps you prepare for that moment of shock so that you can engage with the professor. And the professors here are wonderful. They use it as a teaching tool, not a punishing mechanism. But again, we're looking for that level of mastery, which means you've got to engage. And to help you engage, you have your case brief up and you're ready to respond, because the professor, you'll see this very commonly in a 1L class, will say, tell us the facts of the case, Mr. Jones. Now tell us what the procedural history was and tell us the rule. Obviously, if all you had done was kind of scratch some notes in your case book and you read 20 cases, you're not going to be able to do that. So that's a practical component of the case brief. Okay, next slide, please. So now we're going to talk about each of the elements of the case brief. So you saw very generally what it looked like, but we're going to walk through them one by one, and then we're going to have you work in small groups to create a case brief of your own, okay? So the very first line of your case brief should be the title, okay? The title is going to include the names of the parties, it's going to include the court, and then it's going to include the date. And each of these pieces, though small, are actually quite significant because they tell you quite a bit about the case, okay? So next slide, please. So first, the names of the parties. The first thing that a case will often tell you is whether this is a civil matter or a criminal matter. So I told you that we have federal courts and we have state courts. We also have two types of cases within each of those courts, okay? We have civil matters and criminal matters. When we're talking civil matters, what kinds of stuff what stuff is on the line? Most often in civil matters, it's money, okay? When we're talking criminal matters, what's on the line? Oftentimes jail. It's pretty serious. Okay, so what the first thing you'll have is the name of the party versus the other name of the party. Now the first name that's put at the lowest level is always the person who's bringing the action. Okay, so in a civil matter, the party is most often called the plaintiff. Okay, sometimes it's called the petitioner. It is not called the prosecution. That's what it's called in criminal matters. So this is a very common 1L mistake. They'll say, torts, well, the prosecution brought a case. It's actually not accurate. It's a plaintiff or a petitioner, most often plaintiff. And then in criminal matters, it's the prosecution. Now, for criminal matters on the other side, we're going to have the defendant. Similarly, in civil matters, it's often the plaintiff versus defendant. Sometimes it's respondent, okay? But so the very first thing the titles tell you is which party, who is on which side, okay? And in a civil matter also, you'll know it's very quickly a civil matter because can private people bring a criminal matter? Can I say, I want to prosecute so-and-so and put them in jail? No, you cannot. So you're never going to have a private party versus a private party, like Samuel versus John. You usually use the last names, but Smith versus Johnson, you're not going to have a criminal matter. So you immediately know just by looking at the names, this is a civil matter. Two parties, the one is the plaintiff, the other is the defendant, okay? Can you ever have the government involved in a civil matter? Yes, so sometimes governments are involved in civil matters. Criminal matters, however, you'll always know it could be a criminal matter if you have a government label first, okay? Especially at the trial court. Now, when you get on appeals, sometimes you get things flipped around. But criminal matters, you'll have things like state, U.S., people of Arizona, etc. for the title, and then a private party as the other name, okay? Okay, so that's going to be your title line. Next thing you're going to have on your title line is the court and the date. Now, the court, that tells you what level you are at. So that lets you know where this case is at. Because when a case starts at the bottom and maybe goes through trial court and then appellate court and then Supreme Court for that state, each one is going to create an opinion. So you're going to have a case for each. So you're going to list the name of the court so that you know what level you're at. So you know if you're at the trial court level, at the appellate court level, which means it's already been heard once. So you always list the name of the court. And then you can just list the year. Why do you think the year would be helpful to know? Yes?
How recent it is.
Yes, how recent it is. Okay, whether it might have been overruled. And just to give you some context, right? If this is a trespass case in 1912, we're going to look at it maybe a little bit differently than 2015. Okay? So just a quick reminder on court and date. Two systems in the U.S. We talked about jurisdiction, how you start, and then appeals in the Supreme Court. One final note on this is what's in a name. One of the easiest ways for 1Ls to get confused when they're reading cases, if we can go to the next slide, is you look at the name of the court, and you think, okay, that must be an appellate court, or that must be the state Supreme Court. Well, bad news, all the states are not all on the same page with what they call themselves. So here's a great explanation from Wikipedia. Because state Supreme Courts generally hear only appeals, some courts have names which directly indicate their function. In the states of New York and Maryland and in D.C., the highest court is called the Court of Appeals. In New York, the Supreme Court is the trial court of general and limited jurisdiction, and the intermediate appellate court is called the Supreme Court Appellate Division. Weird. Maryland's jury trial courts are called circuit courts. Non-jury trials are usually conducted by the district courts, whose decisions may be appealed to the circuit courts. And the intermediate appellate court is called the Court of Special Appeals. West Virginia mixes the two. Its highest court is called the Supreme Court of Appeals. So what's in a name? I don't know. They're not all on the same page. So always just kind of be on the lookout. If it's something like the Supreme Court of Appeals, it might actually be the Supreme Court. And once you get into the case, you can figure it out. But just be a little bit wary when you see those labels that you don't automatically assume, well, every court in the country is called the Utah Supreme Court if it's the highest, and it's called the Utah Court of Appeals if it's the middle. That would be great. Maybe one of you could work on that in your future legal career, but that's just not how it is right now. Okay, so next, after you put your title, so you're going to have party versus party. You're going to have the name of the court, like Utah Court of Appeals. Then you're going to have the year. The next thing that you're going to do is summarize the facts, okay? If we can get those bullets up. Why would you include the facts and how much should you include? Again, we talked about this. You can be assigned 20 cases for one day. So you're going to very quickly forget the facts. And so it's just a couple lines to remind you what the case was about. Now, if you have read the case carefully and you understood it and you kind of did some good learning with it as you went, you should be able to write a couple lines, even if it was a 200-page case, which, again, those happen, well, just so you know, those happen very rarely. We're thinking constitutional law, and that's like one case, a half of a case, a class period. So don't be stressing thinking, no, you're reading 2,000 pages. Torts, property, you're getting a couple pages kind of a thing. But, again, a lot of cases. So you include the facts, and if you've read it well, you should be able to include a couple lines of reminder facts, and you say, yes, I remember that case. I remember all about it. I remember this and that and the other. If you have not read it well and you're writing down 36 lines of facts, it's a good sign that you probably need to go back and read it again, okay? So just a couple lines of facts to remind you, oh, yes, I remember this was the dog trap case, and here's what happened, and blah, 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 okay? The next section that you include is what's called the issue. The issue you should be able to do in one sentence, and you should frame it in a question format. Okay, how do you find it? Some courts are really nice, and they say the legal issue before the court is. Some never say that, so you have to go digging. But what the issue is when I talk to you about how we have the statutes, and then the courts have to fill in all the stuff, it's the question of what they're trying to fill in. So, does intentional include intentionally choosing to take a medication that would render you unable to make a good decision or whatever? So it's the little wrinkle that they're trying to figure out. That's what the legal issue is. It's how are we, what specific question of law are we looking at, okay? So that's the issue. Next slide, please. So you answer that issue, which you'll frame in a question format with the rule. Like, yes, when a person chooses to take a medication that renders them unable to make a conscious decision, they have intentionally chosen that, and that results in intent existing for trespass, okay? So the rule is what's known as the black letter law. It is the answer to the issue, and it is the common law that's the most important part of the case, because that's what we're going to take, and all the lawyers are going to look at who come and research this later and say, aha, this was the rule, this is the law, this is what is the case for Utah, okay? Should it be general or specific to the case? Because this is a principle that we're going to pull out and take other places, we don't want to say, for Mr. Johnson, he was trespassing. That's not a helpful principle, right? What we can say is for an individual that takes medication, we can pull that out and we can translate it other places. So you want to put it in more general terms, okay? Why is it so important? Well, this is the black letter law, and I'll give you a quick math analogy that I think is really, really helpful. So when you start your first year, you're just reading case after case after case after case, and sometimes it becomes really confusing. Why do we just read cases? Why don't they just give us a list of laws? Can't they just give us a list of the laws and we'll just memorize them? Well, for two reasons, okay? First of all, if you don't understand how a law works, I can give you the quadratic equation today, right? If you have no practice problems, you're not going to be able to use it. So think of all the cases as practice problems, okay? They're practice problems. So this random torts case is not important because there's 10,000 other torts cases that teach us about trespass. However, it's a practice problem that illustrates the formula, right? The principle that we need to pull out. And because we read the case, we saw how the formula actually works, right? So we have a practice problem. And now we can take it in our torts final. When they have someone who's sleepwalking, we can say, well, in this one case, they had medication, and they were not really intentional because in my case, and you have to do that work. You can't memorize law without context, right? And the second reason is because when you read a case, you aren't just pulling out the principle, you're seeing reasoning. You're seeing the pros and cons. You're seeing how legal minds work, right? So it's the small picture of learning the principle and seeing it work in the practice problem and understanding the context, but it's also the bigger picture of understanding how judges make decisions and becoming that good thinker who can think both sides through, okay? So after you do the rule, again, one sentence, maybe 2 or 3, after you do the rule, the next thing you usually list is what's called the procedural history. This is just an explanation of where the case has been and what has happened in those lower courts. Now, if you're at the trial court level, do you have procedural history? Nope, there's none, is what you write. It's really nice, none. But if you're at an appellate level, you know that the lower courts have heard it, and so you use the procedural history to let you know what happened, okay? Next slide, please. The next thing you put after procedural history is the holding, okay? The holding tells us, now this is really important to understand, different from the rule. The holding tells us what happened to this particular John Smith when the rule was applied to the facts of his case. Was he guilty? Was he liable? So the holding is not the rule. It's not the formula. It's formula applied to John Smith equals he is liable, he is guilty, he is going to be charged, or whatever it may be. Okay? Do you see how that's different? Don't confuse the two because they can be a little bit confusing. Okay, next slide, please. Last section is reasoning. This is where one else probably get tripped up the most, is trying to summarize the reasoning, because oftentimes this is the longest part of the opinion. So reasoning in a Supreme Court opinion could be 100 pages long, and here's all the reasons why we decided this case the way we did, okay? So for reasoning, the best thing you can do is read it and then try to think, can I categorize this? You know, some judges are great. They'll say there's 3 major reasons and here's what they are, and then I'll give 10 pages of explanation on each. Other judges are less organized and it's kind of all over the place. So again, like with your facts, don't end up writing 26 pages of reasoning. Try to think to yourself, well, what are the major categories I could put this in? Well, number 1, it seems like there's kind of a policy concern, like we need to make sure this is a good idea for future parties. Number 2, there's kind of this concern about strictly applying the law, and just try to kind of categorize the reasoning, okay? Lastly, concurring opinions and dissenting opinions. These are most often at your Supreme Court level, where you have justices, when you have a panel of judges, and they either agree with the opinion, but they want to add some reasons that the majority didn't maybe agree with, or dissenting opinions, they don't agree with it and they want to memorialize, I don't agree with it and I want to make sure everybody knows why and here's all the reasons, okay? You're not going to find these in a lot of your trial, well, you're not going to find them in any of your trial court decisions. This will be more in constitutional law, you'll run into these, okay? So, example case brief, if you could pop this up really quick. So this is just to show you how short a case brief could be, if you could hit all the dots on there. So this will show you, this could have been a 5-page case or a 50-page case. Facts: chiropractor was convicted of felony murder, even though the crime of fraud itself is not a violent one, because his cure for cancer did not save the life of a patient. Issues: this is a legal issue. This is what the court was trying to figure out. Under California law, can a chiropractor whose cure for cancer did not succeed in saving his patient's life be found guilty of felony murder based on his act of fraud? Okay? The rule, this is the black letter law, the principle we can pull out and now go and apply to other cases. No. Under California law, in order to invoke the felony murder rule, the prosecution must show that the felony the defendant committed is one that is inherently dangerous to human life. Fraud, is it inherently dangerous? Probably not, okay? Procedural history, the lower level, he was guilty, it was appealed on jury instruction. Holding, what happened when we took the rule, applied it to this guy? They reversed the lower court's decision and said he was not guilty. Reasoning, you'd probably have a couple bullet points. Here are the major reasons, and then if you had concurring or dissenting, okay? Again, a half page, three-fourths of a page is what you're looking at for a case brief. Okay, now we're going to take 5 minutes. I want you to work in groups of 2. Hopefully you read that case. If not, please join a group of 2 that did and just kind of listen in, because we don't have time for you to read the case. But we have the case of Girard versus State, Maryland Court of Appeals, 1991. I want you to work in your groups of 2 for 5 minutes, and if you could go to the next slide, please. We've got a sample case brief here that you need to fill in, and just get through as much of the case brief as you can, working in pairs. Again, if you didn't read the case, please go back 1 slide so they have the template. If you didn't read the case, just jump in with a group that did and kind of listen to their experience as you write your case brief. So ready, set, go. 5 minutes, please. Zip through a couple final things. So first of all, congratulations on doing your first case brief. It wasn't so bad, right? Get prepared to do like hundreds more. I hope you enjoyed it. So let's go ahead and zip through this one. Now, if we went to class, how would class start? It would start by the professor saying, Taylor, could you please share the facts of the case Girard versus State?
For sure. So Stephen Gerrard was in an argument with his wife, and it escalated to the point where he went to the kitchen, grabbed a knife, and stabbed her 19 times. He was found by lower courts to be guilty of murder, and now he's appealing to the highest court in Maryland, the Court of Appeals, to lower his sentence from murder to manslaughter.
Okay, excellent review. Can you go ahead and flip through those?
You actually have control now, so you-
I have control. Oh, this is wonderful. No, it's okay. I try to put in fun stuff. So there you go. That's my sense of humor. So excellent. Very good review of the facts. Not too long, but also specific enough that it wasn't just, well, there was a murder, right? But he didn't go on for pages and pages. So sometimes nervous when I was doing, the professor's like, talking for 7 minutes. So yes, good, simple review of the facts reminds you what the case is about. Let's see. Christy, could you please share the issue of the case with us?
So the issue is to determine whether words alone are provocation adequate to justify conviction of manslaughter rather than a second-degree murder.
Okay, excellent. That was the legal issue before the court. Words alone, are they enough? Laura, could you please tell us what the answer was? What was the rule?
In this case, words alone were not enough to justify conviction of manslaughter rather than second-degree murder.
Okay, excellent. So the rule is no. Words alone are not enough to constitute adequate provocation to mitigate murder to manslaughter. Now, if we had a little bit more time, I'd march through the rest of this. I'm just going to go through it quickly here. Procedural history. Obviously, we know there is procedural history in this case, given the title. So the defendant was convicted at the lower court of second-degree murder, holding what happens when we apply the law to this particular defendant. The Court of Special Appeals affirmed. When we apply the law to this defendant, the holding is affirmed. The defendant is guilty of murder. Reasoning. So what was the reasoning? If we had time, we'd go through this. If you tried to kind of chunk it up, these are kind of the three major reasons that the court talks about. First is the issue of precedence. In our own jurisdiction, we've never expanded things this far. We're not going to do so today. We're looking at other jurisdictions. We're looking at treatises. For all of these reasons, we feel like there's really good precedence for keeping these categories limited. Historical traditional argument. So traditionally, just kind of in the history of the United States, we've had this for a limited amount of categories, the most common being the spouse discovering the affair, and they're right there, and they commit the act of murder, and then they're able to claim this. So they've said, just looking at history and why we created this, we don't want to keep expanding this. And then there's policy argument, which is just the idea of, is this a good idea or not? And this is my favorite quote from the case. This is good for all of the married people to know. There is no reason for holding in favor of those who find that the easiest way to end a domestic dispute is by killing the offending spouse. Good thing to keep in mind. Okay, so generally in class you'll get through that in a couple minutes, maybe 5 minutes, maybe 10, and then you'll get to the best part of law school, which is the discussion. Okay, so we're going to do that for a couple seconds. So, first question is, should the standard be a subjective one rather than a reasonableness standard? The court says the standard is one of reasonableness. It does not and should not focus on the frailties of the mind of the defendant. So, I want you to think through your life, okay? And hopefully this is not you, but do you know somebody who has a really hot temper? Can just fly off the handle really quickly? Yes? No? Okay? Shouldn't we give those people a break? I mean, some people are enraged more quickly than others, right? And the whole reason, think about this, the whole reason for adequate provocation is, have you ever been so angry that you're kind of out of your mind? Hopefully you didn't kill anyone. I doubt you did, or you wouldn't be here. But the idea that we actually lose control of our mental faculties, right? We're so enraged. And yes, I've had these moments, and I take a second and calm down. But that's what we're looking for, that moment, right? So why shouldn't we make this a subjective standard? Well, some people become angrier quicker than others, right? Let's see, is it McKay right here? McKay, should it be a subjective standard?
I don't know. Personally, I think that it should be reasonableness, because we can't just excuse somebody for flying off the handle. And there are ways to try to master your own anger.
Okay, ways.
I think you could go to counseling.
Okay. So you'd say we can't make excuses for the hot-tempered people in our society. Is there anyone who disagrees? Who thinks, no, we should be looking at the particular mind of the defendant? Nobody. Yes, you'll stand up for those frail defendants.
Well, this is actually one of the problems I had with this case, was that I feel like provocation is different for each person. And I don't know how the court would determine that, which is, I guess, why we just have to go with the reasonable man standard. But it makes sense to me that someone could be adequately provoked and be out of their own mental state and commit a murder that they did not intentionally mean to do. So I don't know how they would implement that, but if we could take that into consideration, I think it would be really helpful.
Counselor, response?
It's true that different people have different things that provoke them, but there's no way for us to determine what those are.
Bring in the witnesses, bring in their therapists, have the jury members hear the evidence and decide for themselves? Maybe? Okay. Next question. When is enough enough? So the court talked about this, and they said words are never enough. Never enough. I mean, you read the facts of this case. This was pretty extreme, right? She's following him around and basically telling him you're a loser, and I'm going to leave you, and you're going to be court-martialed. Raise of hands. Does anyone disagree and say, you know what, there is a point where if somebody followed you around for 5 hours straight and said horrible things and threatened your career and talked about your family and all these things, yes, you could snap. Is there anyone who thinks that words alone could be enough? Okay, so you actually disagree with the court. How many think words with the ability to cause harm, right? They looked at the size of the people, but what about if we said words plus they could actually harm you? Raise of hands. Or I guess we could expand that. What about words with threatening actions? Right? Raise of hands. Okay, what about words with actions of betrayal? Like walking in on the affair. How many people think that's adequate provocation? Okay. Is there any people who think that we shouldn't allow the defense at all? Like, this is stupid. We're not going to let people say, well, I was provoked. Is there anyone who wants to stand up for that position and say, no, if you killed someone, you killed somebody? Now, keep in mind this as you're thinking through this. Who is the witness of the events that occurred in this case? The husband. Were there any other witnesses? No. So how often do we even get an accurate story? When we have one person who kills one or two other or however many people, do we even get an accurate recounting? That's why a lot of people criticize adequate provocation. Of course he says this. What if he just went home and stabbed her? We'll never know, right? So should we allow this defense? Is there anyone who wants to say, no, this is a terrible idea? Yes?
Well, it seems like regardless of the provocation or lack of provocation, they're as much a danger to that person as they would have been if he'd been thinking about it for 6 weeks and planning it out. He still killed her in the end.
The result was the same. So we should treat them the same. What if you're texting and driving and you kill somebody? Should you be treated the same as the man who plotted a murder for 6 weeks? The result's the same. No. Okay. So at some point you think it does change intent, but not here? Okay. If we had more time, I'd back you into a really fun corner. Which is always intentional, but it's good because as lawyers, you have to think about the positions you're taking, right? Well, we are just about out of time, but this is how class goes, and it's so much fun. And you go back and forth, and you get backed into a corner. Especially, there's some really talented professors here. I had one classmate who finally broke down one day, and he's like, stop it, I know what you're doing, and I'm not going to do it. But it's all teaching you to think about the ramifications of what you're saying and the laws you're proposing, because someday you will be lawmakers, you will be defenders of the law. It's so fun. Class ends, you go back to your little desk upstairs, and then you think, that was really awesome. What did that have to do with the law? We had this really great discussion. Johnny said, Julie said, how did that teach me about the law? Okay, so here's the final thing I'm going to teach you, and then we're going to call it a day. What were you supposed to learn? 2 things in every class period you're looking for. First, you're looking for that black letter law. Did we spend much time on it? No. You'll skim on it pretty quickly, but you are learning it as you read the case, as you see the formula, but you got to pull that out, the black letter law. Second thing, the reason we spend so much time on discussion is because we're teaching you to think like a lawyer. So don't get frustrated saying, why doesn't my professor just write 10 laws on the board and we all memorize them and we all say them 100 times? Because they're thinking of teaching you how to think like a lawyer and think of ramifications. Okay. So small picture, black letter law. This is what you were supposed to get out of this case. Adequate provocation, not just words alone are not enough, but note that when you read a case, the professor's not going to assign a case for every single element because it doesn't work that way. It's not clean like that. Like, I'll give you a practice problem for number 1 and number 2 and number 3 and number 4, and now we'll learn practice problems for, it's not how cases work. So you have to pick up the major law, but if you also read that case, you saw the court set out the elements, right? So you might read 3 or 4 cases about adequate provocation. They all might be about slightly different things. At the end of the day, what you want to pull out of that is these are the 4 elements of adequate provocation. Here are the exceptions. And now when it shows up on my torts final, I'm able to talk about adequate provocation. So how are you supposed to find it? You look for it. And you have the rule of the case, but you're always thinking about that other picture of where does this fit in the bigger structure of law. So what I recommend in class is having a split screen. So you always have your case brief on the left, and then on the right side you have your law. And we'll talk about outlining with the ASP mentors. I think we'll teach something about it. But outlining is basically just the law. So it'll have criminal law, crimes, defenses. Underneath defenses, you'll have adequate provocation. Underneath adequate provocation, you'll have 4 elements, and you'll see, this is where this case fits. It's a part of a defense. It's element 1. It's an exception to element 1, okay? So again, why do we read cases? To learn the black letter law instead of just memorizing the law. We talked about that. It's like the practice problems approach. You have to have that context. And again, or lastly, the question about why do we spend so much time on discussion in class? Sorry, as I'm trying to wrap up quickly here. It's because we need that also, not just learning the law experience, but also the experience of learning to think like a lawyer. But you always want to keep both in mind. That's why the split screen approach is helpful, and why it's helpful in class to be thinking as you're having these awesome discussions, hold on, let me make sure I know what law we're talking about and where it fits in the bigger scheme. Okay, so here are just some final points of conclusion. Before class, read carefully, make your case briefs, bring them with you. During class, be prepared to answer those questions, but also keep in mind that small picture and the big picture as you go back and forth. Okay. That is it for today. Thank you so much for coming. I will stay for a little bit after and happy to answer questions, as I'm sure our other representatives are too, but we are super excited to see you the first week of law school. Excited to see if you'll be in my class, so have a lovely day.